All right, good afternoon, Mr. Sanders. Can you see and hear me okay?
Yes, Your Honor.
Okay. Court calls CR 21-5, CR 21-6. State versus Brittany Cheyenne Arnold set for pretrial today.
Yes, Your Honor, and we don't have any pretrial issues, and we just asked to have it set for a docket call.
Okay, there being no contested pretrials, court will set this for docket call. Do you have your calendar available, Mr. Sanders?
Yes, Judge, I was going to say either the week of, I guess that'd be June 7th or the June 14th.
Either one of those are good?
Yes.
Okay. How about June 15th?
Okay. Yes, that'd be fine.
All right, we'll set it for docket call June 15th at 9 a.m.
Ms. Beasley?
All right, court call CR 19-305, State versus Donald Brian Ellis set for pretrial today. Ms. Beasley?
Yes, Your Honor. The court provided the defense with some money for a DNA expert. I've contacted her and have emailed her what I consider be the necessary documents for her to review. And I would ask for additional settings so that I have a chance to confer with her before I can make an announcement to the court.
Do you know how long it's going to take for her to review that evidence?
I do not, Judge. She wasn't able to give me a time frame yet, so I would ask for a 30-day reset at this point.
Are you available on June?
No. June what, sir?
June 15th?
Yes, sir.
All right, we'll set Mr. Ellis for additional pretrial on June 15th to allow the defense expert time to review the discovery.
Thank you, Your Honor.
Ms. Beasley, is there any other issues we need to take? Is there any other issues we need to take out with Mr. Ellis before we go?
No, sir, not at this time, not that I'm aware of.
Mr. Ellis, you agree?
Yes, sir.
Yes, sir.
Okay. All right, we'll see you back on June 15th.
Mr. Alexander. Mr. Alexander wants to do it.
All right, is this Mr. Alexander?
This is, Your Honor.
All right, so we're going to be conducting a plea today.
Yes, sir.
All right, Mr. Alexander, if you will raise your right hand. Mr. Alexander, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you put your hand down. Make sure you speak up loudly and clearly. I got to make sure that my court reporter who's present with me on this side of the computer can hear everything so she can take down a record, okay?
Yes, sir.
And there might be a little bit of delay in our technology today. So if there is, I ask you just bear with me. All right, you are Vince Leon Alexander, is that right?
Yes, sir.
And Mr. Alexander, are you a citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Miss Deborah Beasley. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss the case with her and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you have reviewed, and signed that you do not understand?
No, sir.
And Mr. Alexander, I'm going to hold up a document here, and I'm going to try to get it in the camera. I'm going to ask if that is your true and correct signature.
Yes, sir.
Okay. And you only sign these documents once you were satisfied that you understand everything that you were signing, correct?
Sure.
All right. Ms. Beasley, do you believe your client to be competent today, and have you explained to him his legal and constitutional rights?
Absolutely, Your Honor.
All right, Mr. Alexander, I see that the agreement is that you're going to be pleading guilty to a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams in exchange for the state's recommendation to the court that your punishment be assessed at 13 years confinement in the Texas Department of Criminal Justice with a $1,000 fine, $290 court cost, $180 restitution, and a $20 reimbursement fee. In addition, the state appears to be dismissing a resisting arrest, search, or transport under section 1245. And you would have 95 days credit towards that sentence for the time that you spent in jail. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
All right, Mr. Alexander, a first-degree felony offense carries a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice, and also a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
All right, and understanding that, then how do you plead to the charge of possession of a controlled substance, penalty group 1, greater than or equal to 4 grams, but less than 200 grams? I'm sorry, it's
Judge, it's manufactured delivery.
Yeah, I just realized that. Let me correct that for the record. The charge is manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, but less than 200 grams. How do you plead to that charge?
Guilty, sir.
And Mr. Alexander, are you pleading guilty because you are guilty of committing that offense?
Yes, sir.
And has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt at this time. Ms. Beasley, any objection to states 1?
No, sir.
All right, states 1, stipulation of evidence is admitted, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close.
What about from the defense?
Rest and close, Your Honor.
All right, I'm gonna take just a moment and review the evidence. All right, Mr. Alexander, based on the court's review of the evidence, I do find that there is sufficient evidence to convict you. The court will follow the plea agreement in your case. The court convicts you of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams, assesses your punishment at 13 years confinement in the Texas Department of Criminal Justice, orders you to pay a fine of $1,000, $290 court cost, $20 reimbursement fee, $180 restitution. Court also dismisses under section 1245 of the Texas Penal Code, DA 2021-252, a resisting arrest, search, or transport. And the court awards you 95 days credit for the time that you have spent in jail on this cause towards your sentence. Mr. Alexander, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of this sentence. Good luck to you, sir.
Sir.
May he be excused, Your Honor?
Yes, that'll be all.
Did you get a thumbprint from him? Awesome. And Judge, do you have my bill on the case?
I think let's see here. I've got the plea papers. And I don't see your bill attached to it, Ms. Beasley. I've got,
Then can I email it to the court?
yeah, you can e-file it if you want to.
Thank you, Your Honor.
You're welcome.
That's excused.
Yes, ma'am. Is that all you have today?
Yes, sir.
All right, thank you.
Good afternoon, Your Honor.
Good afternoon, ma'am. How are you?
I'm outstanding. Thank you, sir. We've got the next three already requested. They should be up shortly to begin with Mr. McCaslett and his client. They're just not here just yet.
Okay, that's fine. I got a couple things I can take up here.
Thank you.
All right, this is cause number CR 2222, State versus Chad Allen Ostrick. We've called the case earlier and I ordered you to go speak with Mr. Manning, who you indicated you wanted to speak with. And so did you hire Mr. Manning?
I actually spoke with partner, Mr. Richardson.
Mhm.
He should ask about it. Couple of weeks with that long time.
Okay. Okay, I'll tell you what I'll do. Today is the 11th. How about I'll have you come back on June 1st? I'll give you a couple weeks. Okay.
You're done.
Yes, sir.
Yes.
She's gonna bring you this form. If you'll just sign at the X, she'll give you the yellow copy and then you'll be free to go.
Thank you, sir. I apologize if I seem frustrated.
That's okay. I understand.
Lost on stuff.
I understand. No worries. All right, Deputy McLeish, who do we have here?
Yes, sir. There'll be Mr. McCaslett and Mr. Mendez Gonzalez.
All All right, court call CR 2034, State versus Remedios Mendez Gonzalez. And we're set for arraignment today. Has Mr. Mendez Gonzalez had an opportunity to review the indictment?
Yes, he has, Your Honor.
All right. Is his name spelled correctly?
Yes, Your Honor.
And does he understand the range of punishment and the nature of charges that have been brought against him?
I have gone over that, and I believe he understands it, Your Honor.
All right. And how does he wish to enter a plea?
Not guilty, Your Honor.
All right. And does Mr. Mendez Gonzalez, does he speak English as well?
A little bit.
Is he going to need the use of an interpreter?
You need the use of an interpreter. Do you understand?
No,
everything?
no, we need it.
You need it for right now?
Yep.
¿Quieres un intérprete este momento?
Pues para entender.
Okay. I guess he's asking for an interpreter, Your Honor.
Well, that's something that you have to notify the court and we have to set up for an interpreter. We don't have an interpreter that just comes in when we call them.
Can I have a time, minute just to explain to him, Judge? what,
Yes, please.
About the
Yes.
procedimiento. Todo lo que quieren saber es si tienes dos cargos imputados, si entiendes que como te culpable, es todo. Necesitas un intérprete para eso, ¿no?
No, pues nomás eso me van a preguntar. Está
Sí.
está bien.
He says that, Judge, basically that's all I'm going to be asked is how do I plead guilty or not guilty, and have I had the charges read, and do I understand them? He doesn't need an interpreter today, but I think that in the future he's concerned, he wants to understand more about what's going on. But for purposes of arraignment, Judge, I think we're okay.
Okay. All right. I'll make a note that we'll have to coordinate an interpreter for future hearings. All right. So the court's going to find that Mr. Mendez Gonzalez has been formally arraigned and has pled not guilty. The court will enter that into the record and will set Mr. Gonzalez for a pretrial hearing. And so, Mr. McCaslett, the pretrial hearing will be the time in which the court will entertain the contested pretrial motions. So I'm going to give you a date here, and I want you to consult your calendar so that you can make sure that you're available. Are you available on June 15th or July 1st?
Let me check, Your Honor. June 15th. Did you say June 15th or July 15th, Your Honor?
June 15th or July 1st.
I'm available June 15th, Judge.
Okay, so
I'm
what we'll do is
available.
we'll set it for pretrial on June 15th. And so 7 days prior to that, if you wish to have a motion to suppress or a motion to quash heard, you'll need to have that filed. We won't hear it on June 15th. Rather, that's just the next setting in which you have to have those filed 7 days prior to it. If you don't request any type of contested pretrial motions, then on that date, we'll just make sure that you have all of your discovery available to you. And then the next setting would just be for a docket call, okay? Which would give you all more time to continue to negotiate the case and hopefully come to a resolution. So at this time, Mr. McCaslett, have you had an opportunity to speak with the DA's office to make sure that you have access to the online discovery portal?
I've had the opportunity to speak to Ms. Heisel, Judge. She's been very, very cooperative. However, I don't believe I've gotten the stuff yet. Through no fault of the DA's office. I just haven't had the opportunity to look for it, but I will be looking for my discovery here.
Okay. All right. So Mr. Gonzalez, this will be the last notice that you get from this court is that we'll return on June 15th. If you make bail in this case, the case will be heard at 9 a.m. If you remain in jail, it'll be heard at 1:30. And we'll give Mr. Gonzalez that yellow appearance form, and then we'll be adjourned in this hearing.
Thank you.
gonna be CR 20-00034. Thank you, sir. Sir, you got to Mr. Manning, Mr. Zimmerman.
Thank you, may we be, am I excused, Your Honor?
Yes, sir. Thank you. It'll be just one moment, Mr. Manning. I'll ask him. Yeah, go ahead, text. All right, Mr. Manning, who do you have with you?
Judge, I have Mr. Zimmerman, Michael Cody Zimmerman.
All right, cause number CR 2374-375, State versus Michael Cody Zimmerman, set for docket call today. Go ahead, Mr. Manning.
Yes, Judge. Last night I had the opportunity to discuss with Ms. Heisel at the end of day, close of business, a new offer being extended to my client. At this point, due to the new jail policy, I've been unable to communicate with my client, discuss that offer with him fully, and fully advise him of the consequences. So I'd ask for a reset for him to consider that offer.
How much time does he need? Is this something we can do this afternoon?
No, Judge.
What's the offer?
But we can do it. The new offer, my understanding, the new offer is to me 25 TDC.
What was the previous offer?
60.
60.
And so had you already discussed the 60 with him?
I'm sorry, Judge.
Had you already discussed the previous offer with him?
Yes, Judge. And we were making preparations to be ready to announce ready today for trial, but like I said, Ms. Heisel contacted me yesterday.
Are you available on June 1st, Mr. Manning?
I believe so, Judge.
All right, court will grant an additional docket call until June 1st so that you can discuss that with your client.
That's fine.
Your Honor,
Yes, ma'am.
Mr. Schmidt has a plea ready with Liza Langley.
Okay.
Ms. Langley, come on.
right, and I don't believe that I have the plea paperwork with me here, so I'll need someone to give me the terms of the plea.
Judge, basically this, Ms. Langley is charged with second degree possession. The terms of the plea agreement are that the finding of guilt will be deferred, punishment assessed to 4 years community supervision, $1,500 fine, 180 restitution to DPS, and then 1245 F19-00199 under 1245 of the Texas Penal Code. Those are the terms.
Mr. Schmidt, I'm going to ask for your forgiveness because I was
Do you
not,
have me on the Judge?
I was not prepared to write that down. I was flipping through my docket. I thought I was on the right one, but I was not. I think I heard you say 4 deferred, but will you get that?
That's correct. Yes, it's 4 deferred, $1,500 fine, $180 restitution, DPS laboratory, and then 1245 F19-00199 as a condition or consideration.
Any reimbursement fees?
Judge, there's court-appointed attorney's fees, $815 total on reimbursement fees.
Court cost $290.
Correct.
All right, Ms. Langley, if you'll raise your right hand, I'm going to place you under oath. Ms. Langley, do you swear that the testimony you give to the court today is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you put your hand down. Make sure you speak up much louder than that, because it's gonna be hard for me to hear you. If it's hard for me to hear you, my court reporter can't hear you either, okay? And you can't shake your head. You got to say yes or no.
Yes, sir.
Okay. Ms. Langley, you are Liza Ann Langley, is that right?
Yes, sir.
And Ms. Langley, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
What have you been diagnosed with?
Schizophrenic, bipolar, and depression.
Are you currently undergoing treatment or on any medication for those?
Yes, sir.
Do you feel like you have rational thought and understanding today?
Yes, sir.
Do you understand the nature of these proceedings and these charges that have been brought against you?
Yes, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
Yes, sir.
And you've gone over some paperwork today and you've signed various things, various documents. Do you understand everything that you've read and signed?
Yes, sir.
Is there anything in that paperwork that you do not understand?
No, sir.
Are you pleased with Mr. Schmidt's representation of you and feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Mr. Schmidt, do you believe your client to be competent today? Have you explained to her legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea?
I do believe she's competent, Judge, and I have explained to her her legal rights as well as the pros and cons of deferred adjudication.
Mr. Schmidt. Ms. Langley, you are charged by indictment with a second-degree felony offense of possession of controlled substance in penalty group 2 greater than or equal to 4 grams but less than 400 grams. That carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
You understand that if I approve this plea agreement today and I place you on community supervision, if it's later found by this court that you violated your conditions of probation, the court could revoke your community supervision, could adjudicate you, convict you of this offense, and sentence you in prison anywhere between 2 and 20 years. You understand that?
Yes, sir.
Do you feel like you can be successful on community supervision?
Yes, sir.
All right, Ms. Langley, then let me ask you, how do you plead to the charge of possession of a controlled substance in penalty group 2 greater than or equal to 4 grams but less than 400 grams?
Guilty.
Are you pleading guilty because you are guilty of committing that offense?
Yes.
And has anyone threatened, forced, or pressured you to be guilty to this charge?
No.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to states 1?
Objection.
States 1 is admitted in evidence, and the court takes judicial notice of the defendant's judicial confession. Other than a summary of the facts, anything further from the state,
No, Your Honor, the state would rest and close.
from the defense?
Judge, I would say that Ms. Langley is going on for deferred. She's also getting a similar offer out of a different county for a similar offense. So she won't be immediately being released today. She'll be transported to tend to those other charges. So just for the record, I understand that she'll eventually need to meet with probation to get all things put together, but that might be a minute depending on Dallas County and transport.
Okay, thank you for
Other
that.
than that, we wrestle.
Appreciate the update on that. All right, State, if you can give me a summary of the facts to support the plea.
Yes, Your Honor. Miss Langley was the passenger in a vehicle that was pulled over for a paper tag that was unreadable by the officer. The driver of that vehicle, Miss Langley was actually the owner of the vehicle, but she was not the driver. She was the passenger. The driver of the vehicle was acting what the officer believed to be very nervously, wouldn't make eye contact. They asked Miss Langley for permission to search the vehicle since it was her vehicle, and she consented. And they noticed when she got out that she was trying to take a bag with her. So they asked for consent to search the bag as well. And when they did, they found 4.38 grams of THC cartridges that were marked with marijuana plant leaves on them, Your Honor.
Thank you, Ms. Heisel. Mr. Schmidt, any objection to that summary?
No, Judge, I don't object to that, sir.
Okay.
Based on the plea.
Then based on the evidence presented to the court will find that there is sufficient evidence to convict the defendant of this offense. However, the court will follow the plea agreement. The court places Ms. Langley on deferred community supervision for a period of 4 years. Court assesses a $1,500 fine, $180 restitution, orders her to pay reimbursement fees of $815 and $290 court costs. Court finds that the state is considering F-19-199 under section 1245 of the Texas Penal Code. Ms. Langley, once you do resolve your business in other counties, ask that you report to your community supervision officer here in Van Zandt County so that you can get started on your community supervision obligations, okay?
Judge, also, I would let the court know that we tendered the plea paperwork to Deputy McLeish. Those are not sworn, but they're also not signed by the state, but she has possession of those documents.
All
We
right,
have to
thank
sign
you.
them.
All right, thank you.
Yes, sir.
And so let me ask you, Ms. Langley, your signature as it appears throughout the documents, that is your true and correct signature?
Yes, sir.
And you only signed once you understood everything you were signing, correct?
Yes, sir.
All right, thank you, Ms. Langley. Good luck to you.
That's all I have, Judge. I have your excuse.
Yes. All right, court calls CR 2186, State versus Courtney Michelle Odom, and also CR 2187, set for docket call today. Mr. Manning?
Yes, Judge. At last docket call, if you remember, we were given new discovery to review by the state. I went to the DA's office and began reviewing that discovery and found that there was not just one lengthy video, but 4. I've only been able to get to the one, so I request that I be able to get the June 1st date to review the rest of the discovery and go over that with my client. She is down in Henderson County, so it will require a trip down there for me to go those things with her. So if we can get to June 1st, that should give me enough time.
Any objection from the state?
Judge, the state doesn't object to June 1st. However, I've been notified by Ms. Curry that after that date, we will object to any future resets.
Okay. All right, court sets Ms. Odom then for additional docket call on June 1st at 1:30 p.m.
Judge, I believe it concluded our business. May we be excused?
Yes, sir. Thank you.
Thank you, Judge.
Your Honor,
Yes, ma'am.
are you ready for Mr. Gimbel's?
Yes, I assumed since he was standing there that we were just waiting for the inmate to come up.
Yes, sir. They're here.
Oh, they're present, Judge.
Okay.
Oh.
Who are we going to go on first, Mr. Gimbel?
We have Matthew Grace, Your Honor.
CR 2167, set for pretrial. Go ahead.
We have no pretrial matters at this time, Judge.
All right, court will set Mr. Grace then for a docket call. And that'll be the time, as you're aware, Mr. Gimbel, then I'll want you and the state to see if there's going to be a resolution in this case. If not, then we'll place Mr. Grace on the jury trial docket. And did I set you earlier today, Mr. Gimbel?
I believe I had other matters set on June 15th, Judge.
Okay. Court will set Mr. Grace then for docket call on June 15th. And Mr. Grace, if you get out of jail, if you post bail in this case or bond, then you'll need to, your hearing will be at 9 a.m. instead of 1:30, okay?
I understand that. Thank
Okay.
you.
All right, Mr. Gimbel, who do you have next?
We have Terry Elmore, Your Honor.
Court calls CR 2420 and 421, State versus Terry Lee Elmore, set for docket call.
That's correct, Judge. Mr. Elmore has, and Ms. Heisel called me yesterday and extended a revised offer. And I've had limited amount of time to visit with Mr. Elmore. I believe we are very close to resolving this matter. And if we could have one more docket reset, I hope we can.
Is there not a chance to recall the case today and give you an opportunity to speak with him today to see if he wants to accept or reject?
In my visit with Mr. Elmore today, he has indicated that he has some serious health concerns that he would like to raise issue with the court. He has 2 charges he's been held on. And our last appearance before the court was for a bond reduction hearing, and his bond was reduced on one of the charges, but not the other. So he has been financially unable to post his bond. And
Can I say something?
and he has asked me if I would file another motion for a bond reduction for the bond that wasn't reduced.
What's the revised offer? What was the previous offer and what's the revised offer?
The latest offer is 15 years TDC.
And Judge, I don't know that I had formally made a previous offer. Mr. Gimbel and I had talked about a couple of different options, but I believe that yesterday's was the first firm offer that I made on this case.
That's correct, Judge. We had talked about different options, but that was the first hard number offer we were given.
Are you available on June 1st?
Yes, Your Honor.
I don't want to reset it very long, but let's reset Mr. Elmore then for docket call on June 1st. And on that date, he could tell me whether or not he wants to accept an agreement or set it for trial. All right, if y'all want to continue y'all's discussion, y'all can go ahead and step to the back so I can call up some. Mr. Hanser,
Mr. Norman Hanser.
CR 2339. I believe this is on Mr. Hanser's motion to terminate court-appointed attorney. Is that correct?
That's correct, Judge.
All right, Mr. Hanser, raise your right hand. I'm going to place you under oath. Mr. Hanser, do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You put your hand down and go ahead and tell me why I should terminate Mr. Gimbel's representation of you.
Well, sir, I've been over here and.
I can't hear
The
you.
last time.
I can't hear you.
I sat over here. I sat over here and waited 2 hours in the attorney-client visitation room to talk to him. I had no idea about a motion to suppress. He hadn't talked to me. I hadn't even, at that time, hadn't even seen the videos or anything. He got the videos back in January, and he just showed them to me recently. I believe it was April 19th or 13th, excuse me. And whenever I first was appointed Mr. Gimbel, I couldn't get any response from him. I wrote him letters, tried to contact him by phone. For 129 days, I didn't even know what the man looked like and knew nothing of this. And then I filed to terminate him then, and he said the only reason why he knew that he was my attorney is because the court or somebody didn't contact him and tell him that he was my attorney. And I mean, the phone calls are blocked. It's not allowed to be called from this jail. And I mean, whenever he filed the motion, he didn't come over to talk to me about anything. I didn't know what he was filing for or anything. I thought I was going for the termination because I filed it again on the 25th of January, and evidently that piece of paper got lost, is what I was told.
Is that all?
Yes, sir. I mean, like I said, I tried to correspond with him, and he never answered any letter that I wrote him. And it's like, I don't know from one minute to the next what's going on.
Mr. Gimbel, would you like to respond?
I'm sorry, Judge, and I apologize to Mr. Hanser for him feeling left out. I don't accept collect calls at my office from the jail. And as far as letters, written correspondence of my several dozens of clients. I just don't take the time to write an individual note back to mail back to each individual client that I have. And I apologize if he has felt alone. I apologize for the jail staff if he thinks he was left in a, I believe he's referring to a hearing that we held via Zoom, and he was placed in a hearing room here at the jail. And I don't know how the jail staff works or how they conduct the movement of the inmates. So I apologize, Mr. Hanser, is terribly unhappy.
So have you corresponded with him since, or either prior to the motion to suppress? Address his concern about your motion to suppress.
Oh, well, I have addressed, he filed a motion which had, I think, 6 stated concerns, which Ms. Taberham forwarded to me. And I included my time log, all the jail visits and the time spent with Mr. Hanser, as well as I answered each one of the 6 concerns that he stated. And I included that and emailed that back to her. And I provided a copy to Mr. Hanser.
So Mr. Hanser, at this time, have you reviewed the discovery in your case?
The 13th, I believe it was when we seen some videos. And whenever I went to confer with him, he made a statement of, are you going to sit here and complain, or are you going to watch the video? Because the day you held over and said we were going to come back at 1:30 for the hearing on the motion, I didn't even know that the motion was being filed for that. I didn't have any idea what was going on.
Well, I guess we're even. I didn't even know he filed a motion to fire me. I guess we're even on that.
So Mr. Hanser, do you believe that you cannot communicate with Mr. Gimbel at this time in your attorney-client relationship?
No, sir, I don't.
You know, I don't know if I've ever heard a defendant complain about an attorney filing a motion to suppress in a case that he wasn't aware of. I've heard of defendants complaining about not filing a motion to suppress, but you're upset that Mr. Gimbel went ahead and filed a motion to try to get all the evidence suppressed in your case. You're upset about that?
What I was upset about is he didn't even come over and say anything to me about it. I was sitting here and I felt like a complete idiot because he's over in there at the courthouse and I don't know what's really was going on at that time. I figured he would have at least taken 30 minutes to an hour to come over and confer with me and let me know that this is what he was doing. And I mean, kind of like blindsided me because I hadn't seen him for quite some time. I mean, it's.
Mr. Gimbel, do you believe that the attorney-client communication is broken down to the point where you can no longer represent Mr. Hanser?
Judge, he just seems very difficult and unhappy. And the items specifically that he has discussed with me regarding the incident, that he has asked about possible other motions to suppress or other possible motions, I do not believe they would be applicable.
Mr. Hanser, can you hire your own attorney?
No, sir, I can't. I made a statement to him about the other individual that was there at the time of my arrest. I believe that she had my debit card and has been running through. She ran through with the money off of my account. And I said something to him about that, and you know, I needed to do something about that because that's just. I just feel at a loss because I feel like I'm being stonewalled every time I say something to him or even address the subjects of anything that are my concerns about this case because.
Okay. All right. Well, I'll take it under advisement and I'll issue a ruling when I get an opportunity.
Yes, sir.
Let's, is Mr. Hanser set for, I think he's set for docket today too. Is that correct?
Believe so, Judge.
All right, so I'm gonna reset docket call till June 1st. And I'll make a ruling on Mr. Hanser's motion to terminate court-appointed attorney before that time.
Thank you, Judge.
Thank you, sir.
You're welcome.
That is all my business this afternoon. May I be excused?
Yes, thank you, Mr. Campbell.
Judge, may I address the court briefly?
Yes, sir.
I have Tessa Furr on your docket. She was a transfer in from Judge Winter's court. I think she said on a misdemeanor case that it's also my understanding she was recently indicted on a murder charge. And that's what I was initially appointed to. They added me on the misdemeanor later. But obviously, for us, the issue is the murder indictment. So I don't have anything to do on the misdemeanor right now. Do you want it brought up, Judge? Or do you want to just wait and carry it with the murder indictment?
Is the murder indicted?
That's what, yeah, it's my understanding. She was served with the indictment the other day.
Yes, Your Honor, it was just returned at the last grand jury setting.
When was that? When was the last grand jury sitting?
April 30th, I believe.
Do we know if she is set for arraignment on that?
The docket only shows the misdemeanor, Your Honor.
No, I know.
I haven't received this yet of the arraignment on the murder charge.
All right, give me just a moment. Because I can't set the misdemeanor if I don't know when the indictment's going to be set for arraignment to get them going at the same time. So give me just a second. Let me check on that. And no, we won't bring her up.
Okay, thank you, Judge.
All right, the court will set cause number 2019-423, State versus Tessa Furr for pretrial on June 1st. Did you say there's no contested pretrial motions? Is that right, Mr. Schmidt?
Judge, there's none that I know of at this point. I mean, like I said, this case was running without me being appointed to it. I
Okay,
happened to show up to Winter's court, she was there. So I was focused on the felony charges, but at this point, we're not concerned about any contested pretrial motions on the misdemeanor.
well, we'll go ahead and set it for pretrial on the misdemeanor case, and we'll also set the murder case for arraignment on that same day.
June 1st?
June 1st, yes, sir. And that's before you leave, correct?
It is, Judge. That'll be fine. Thank you.
Okay, you're welcome. Hello, Mr. Stevens.
Good afternoon, Judge.
This is cause number CR 20-407, State versus Abram Rice. Hearing on the motion to revoke. Go ahead, Mr. Stevens.
Yes, Your Honor. I was just appointed actually about 2 or 3 weeks ago. I visited with Mr. Rice in the jail just yesterday, I believe yesterday or maybe day before yesterday. I got an offer on him, which he found out what that was just a little bit earlier today. And so I'm going to ask for another setting so that I can visit with him, explain all these options and kind of go from there, Judge.
Okay. What we'll do is we'll go ahead and set it on the contested docket on June 29th. So that'll give you over a month to discuss it with him. And if he doesn't want to accept anything or the state doesn't withdraw their motion, then we'll just go for a contested hearing on the 29th of June.
Okay, Judge, I'm going to be out of town. I got a vacation letter in I leave the 20th of June. I don't come back until the 30th of June.
All right, then let's set it on June 15th.
All right, sir.
All right, is this Mr. Pesnell?
Sir. Yes, sir, it is.
All right, this is writ number WR 21-2. And this is a writ seeking bail reduction, is that correct?
Yes, sir, it is.
Do you want to call your client today?
Yes, Your Honor, for the limited purpose of the bail reduction agreement.
All right, Mr. Pesnell, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay,
I do.
you may put your hand down. Make sure you speak up loudly and clearly, otherwise I won't be able to hear you, and neither will my court reporter. Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
David John Pesnell,
David, how long you been in jail now?
30 days.
30 days, okay. And you have a $50,000 bond set on aggravated assault with a deadly weapon charge, is that correct?
Yes, sir.
And obviously, you haven't been able to raise funds to make a $50,000 bond, is that also correct?
Yes, sir.
Okay. Do you own any property that you could actually sell, pawn, or mortgage, or do you have any money, a substantial amount of money in the bank that you could draw from to post this bond?
No, sir.
Okay. Prior to being charged with this and arrested, you were working at Berkshire's, is that right?
That's right.
Okay. And do you think you still have that job?
I might.
Okay.
I might.
But you don't know for sure?
I don't know for sure.
Okay.
I might.
In addition to Berkshire's, I think you told me that you do construction work.
That's right.
And detailing.
Yes.
Do you have your own construction business?
No.
Okay. And who do you work for or work for?
It's an independent guy and he flips houses and he rents money.
Okay. And if you don't have your Berkshire's job and you get out, do you think that you'd be able to go to work for this guy?
Yes.
Okay.
Yes.
If you were to get out, do you have transportation to get to and from the courthouse?
Yes. My car's paid off.
Okay. And where would you live?
Grant's-Lane.
Okay. And is that where you're from or is that where you're residing? And who do you reside there with?
Me and my wife, we own 322 South First Street.
Okay. Is that the address you go to?
Yes.
Go to? Okay. Now, you've told me you have absolutely no criminal history. Is that correct?
That's right.
Zero criminal history.
Zero.
And how old are you?
50.
50. Okay. And we were talking about the amount of bond that you could actually post. And we're going to ask the judge for a bond around $5,000 and $10,000. Is that correct?
Yes.
Okay. And are you asking the judge to reduce your bond?
Yes.
And are you promising this judge that you will reappear at any time he orders you to appear in court, or if he puts any bond conditions on you to report to the probation department, you're willing and able to do that, correct?
Without hesitation.
Okay. I pass with you, Charlotte.
State, any questions?
Just a few, Your Honor. Mr. Pesnell, have you spoken with any bonding companies?
No.
So you don't even know what it would take for you to get out of jail, is that correct?
That's correct.
Your Honor.
Got $500 ready to go. To post bond.
Sorry, I didn't hear. I'm sorry, Mr. Pesno.
I have $500 ready to go to post bond. That's all I have for the bond. But I have not contacted a single bail box company. It was told to me to wait until I got a bond through my bond through you guys and proceed from there.
Your Honor, I pass the witness.
Mr. Stevens, any further questions?
No, Your Honor.
State, do you have any witnesses or evidence?
No, Your Honor, we would just reserve for argument.
Go ahead, Mr. Stevens.
Judge, we're asking you to reduce his bond to $5,000. He's 50 years old. He has absolutely no criminal history. And he is, prior to being arrested, he was gainfully employed, and he obviously can go back to work. And he's got the ability to go to and from the courthouse or any other obligations the court puts on him. So we're respectfully asking Your Honor to set his bond at $5,000. Thank you.
State.
Your Honor, the state is going to oppose a bond reduction at this time. While Mr. Pesnell may not have any criminal history, the current accusation against him is very serious and is of a violent nature. Furthermore, the state that has received the case in our office, and we do believe that we will have it indicted by that 90-day mark. If we don't, then the state would be willing to revisit this issue. But right now, we don't believe he's entitled to one. And furthermore, based on the nature of the charges, we would ask the court to deny this motion at this time.
All right. Court will take the evidence and argument under advisement, and I will issue a ruling at the end of the docket today.
Thank you, Your Honor.
All right. Thank you, Mr. Stevens.
Might be excused, Your Honor.
Yes, sir.
I'll let you know.
Do we have Mr. Turnage, Mr. Jeff Woods' clients, because he's online?
We do, yes, sir. Mr.
Okay.
Burns, come on up. Stand at the podium, please.
Give Mr. Wood an opportunity to get logged in here. All right, Mr. Wood, are you ready on Mr. Turnage?
I am, Judge. I apologize. That's what happens when I'm in charge of calendaring things. And
all right, this is cause number CR 2198 and CR 2199, State versus Brett Lawrence Turnage. And I believe that we're just set on a status today.
that's correct, Judge. And I got an email today, I believe, from Patty that mentioned that Mr. Turnage was number 296 on the wait list for the for a bed to open up at Rusk, I believe. So compared to what he was the last time that I checked, that is a significant improvement. And so my hope is that he gets sent down to State Hospital relatively quickly.
Mr. Turnage, how are you doing, sir?
I'm good. Is there any way I could say something?
you probably want to talk to your lawyer first. Mr. Wood, you may put him in a breakout room with you so you can find out what he wants to say?
Sure.
So hang on, Mr. Turnage. I'm going to put you in a private room with Mr. Wood so y'all can talk, and then you can come back and let Mr. Wood find out what you want to talk about first, okay?
Okay.
All right, be just a second. Okay. Jason Briggs. I just have a seat. I'm just going to check. So Mr. Briggs, Mr. Williams in the back, your name, sir? Slayton. Okay. All right. So that's yours. Okay. Are y'all ready? All right. Come on up. I'm sorry. I didn't know he was here. I would have called you in a lot sooner. I'm sorry. This is CR 20194, State versus Stephen Kyle Slayton. We're set for docket call today. Okay. And so Mr. Slayton understands that failure to resolve his case with a plea agreement may result in the court not entertaining a plea agreement if one is reached at a later date.
Yes, sir.
All right, Mr. Slayton, the court's going to set you to begin your jury selection docket on Monday, June 7th. So what you're going to need to do is on June 7th at 8:30 a.m., you're going to report downstairs in the basement of the courthouse. And a member of my staff will be down there with the paperwork and your next court date. You're not going to go to trial on the 7th, but we're going to go ahead and start you on that process. And then you're going to continue to do that until your case is reached for trial. Mr. White is not going to be required to be down there. He may be down there if he so chooses, but he's not required by this court to be down there, but you are, okay? So once you sign that and get the yellow copy, you'll be free to go. Yes, free to go, Mr. Slayton. Mhm. Yes, thank you, Mr. White. I'm sorry. Hey, next time you tell me when you're ready to go and I'll get you in there. All right, Mr. Wood, and well, let's see, I see Mr. Turnage. Looks like Jeff may be trapped in the twilight zone. There he is. All right, Mr. Wood, have you had an opportunity to speak with Mr. Turnage?
I did, Judge, and he explained some things to me that weren't really necessarily revolving around this case, but other matters at play. And so I again discussed with him about what this particular hearing was about, and he claimed that he understood that and understands that he's still waiting for a bed to open up down in Rusk.
Okay. All right, and so Mr. Turnage, we are staying on top of the hospital bed availability. My coordinator is consistently checking and doing everything that she can to try to increase your, going down there faster rather than slower. Okay, so we're monitoring it. I don't want you to think that we've forgotten about you in the jail. We're just simply waiting on them to tell us when it's going to be your time to go. Okay. And I'm sorry, I don't have any, I'm not getting any audio from the jail. Is anyone
Jail
else?
court is muted, Judge.
I believe you're muted.
Thank you, Mr. Woodwhack. Sorry about that.
Okay. Do you understand those things, Mr. Turnage?
I do.
Okay.
Yes, sir.
All right. So let's set Mr. Turnage just for another status so that we can check on him. And you have your calendar available, Mr. Wood?
I do, Judge, but yes.
What about July 27th? You available on July 27th?
That'll work.
All right, we're just gonna set him.
That should work, Judge.
We're gonna set him for another status on the state hospital on July 27th. And Mr. Wood and State, I would like to meet with y'all in a breakout room here before you go, Mr. Wood. We'll go ahead and call up Kronberger and get that resolved, but I just don't want to forget, I do want to talk to you.
Sure.
Yes, Your Honor.
All right, Mr. Kronberger, CR 2395, CR 2124. Mr. Kronberger is set for docket call today, Mr. Wood.
Judge, and again, this is one that Mr. Woodwhack and I have been discussing. I would say that we're very, very close to resolving this matter. Quite frankly, had I recalled that this case was set today, I probably would have had it resolved today. Well, I say that we had some things come up this past week and then yesterday that might have influenced that, but I think that this case will be resolved and will be resolved relatively quickly. If you want to set it for next week or the week after, as soon as you want to set it, Judge, I think we can get it knocked out.
State has no objection, Judge.
Tell you what, let's set it on June 1st. I'm pretty much at capacity in the next 2 weeks. So we'll set it for June 1st for docket call.
Okay, Judge.
Thank you, Your Honor.
Thank you, Mr. Kronberg. All right, is Mr. Hunt ready? Do we have Chad Atkins?
He is, Your Honor. Yes, sir.
All right, this is cause number CR 2237, CR 2146, State versus Chad Edward Atkins. I believe we're set for arraignment on the second degree on CR 2146, the newer case. Has Mr. Atkins had an opportunity to review the indictment?
Your Honor, Mr. Atkins and I have received a copy of the indictment. His name is spelled correctly. He understands the charges against him, waives the reading of the indictment, enters a plea of not guilty.
All right, court will enter Mr. Atkins' plea of not guilty into the record on that cause. And I will set the newer case for a pretrial hearing. Are you available on June 15th, Mr. Hunt?
I am, Your Honor.
Okay, we'll set pretrial on June 15th and we'll carry the docket call in the other case on the same date.
And I'm assuming that would be at 9 o'clock if he's released and 1:30 if he's still in custody?
Yes, sir, exactly.
And I emailed with Ms. Heisel in the last couple of days, and she was still attempting to get that 911 recording out of the new case. And we haven't had a chance to talk in the last day or so, so I don't know where we're at on that.
And Mr. Hunt, just for everybody's information, it has been uploaded to the online portal, but I believe it was put in the December case, not in the March case. But it should be on there for you. And if not, just let us know.
Well, and But that is the 911 call from the from the December case is the one I'm looking for. It would have been made by his, I believe his mother or stepfather.
Yes, that's the 911 call I'm talking about. It was whichever case it belongs to, it was uploaded into the other. But if you have a hard time downloading it, let us know and we'll get you an audio disc.
Will do.
All right. Thank you, Mr. Hunt.
Thank you, Your Honor. May be excused.
Yes, sir. Thank you very much.
Thank you.
Aaron, do we have any more inmates in the courtroom there?
Just the ones that you've already seen. We cleared the docket though, sir. We don't have anybody left on the docket for UC.
No, I believe that's all. I just didn't know if I need to go into a breakout room, but I'll tell you what, Mr. Wood is still there, then I'm going to set us up in a breakout, whatever.
Yes, sir.
And so I think that concludes the jail docket for the day. So unless State, you think I've missed anybody on the jail docket?
That's all I had, Judge.
Okay. All right, then. Aaron, thank you very much. Appreciate you.
Thank you, Judge.